The highest court is the Supreme Court of Pakistan, and the highest courts in each province are the high courts. And in the federal capital as well, we have Islamabad High Court as well, so we have a court for the federal capital. General Zia, as I mentioned, had introduced the Federal Shariat Court, which is empowered to decide whether any law is repugnant to the injunctions of Islam. The Constitution also permits the establishment of administrative courts and tribunals to deal with disputes with regard to specific areas, such as service matters and election disputes. The decision of the Supreme Court, to the extent that it decides a question of law or enunciates a principle of law, is binding on all courts in Pakistan. So these are very key words. It must decide a question of law or enunciate a principle of law to make it binding on all courts in Pakistan. The Constitution stipulates that every court's jurisdiction is conferred by the Constitution. All the power that I as a judge have is that I derive from the Constitution. Conferred by the Constitution or conferred by a law. The Constitution confers a number of different jurisdictions of the Supreme Court. The most commonly used one is its appellate jurisdiction. That is when the Supreme Court hears cases already decided by the High Courts or tribunals. The Supreme Court advisory jurisdiction may be invoked by the President to seek an opinion on any question of law which he considers to be of public importance. The Supreme Court is also empowered to decide disputes between two or more governments. The Constitution also confers an extraordinary jurisdiction on the Supreme Court to ensure that the fundamental rights mentioned in the Constitution can be enforced in matters of public importance. This is oftentimes referred to as a suo moto jurisdiction. However, this term is not used in the Constitution. The Supreme Court has held, and I've given references in the article which I won't mention, that public importance excludes any individual grievance, and the matter must pertain to the rights and liberties of the people at large. The other precondition that needs to be met before invoking this jurisdiction is to ensure that it is in respect of fundamental rights. Sometimes these are referred to as human rights, which are set out in Chapter 1 of Part 2 of the Constitution. And these are very specific fundamental rights, and just list some of them. There are more than the ones I mentioned. They refer to the security of persons, life and liberty, safeguard with regard to arrest and detention, right to a fair trial, privacy of home, dignity of man. I mean, it can be that an individual's right has been transgressed. A man has been arrested without a warrant. He cannot go to the Supreme Court because while it is a matter of fundamental rights, it's not a matter of public importance because it affects one person. Freedom of movement, freedom of assembly, freedom of association, freedom of speech, and the equality of citizens. There are many others. An aggrieved person may file a petition in the High Court. This is a normal route of filing a petition is in the High Court if he has any grievance within whose territorial jurisdiction the infringement of the fundamental right has occurred, and the High Court is empowered to pass an order, sometimes referred to as issuing an appropriate writ, to enforce fundamental rights. This power may also be exercised by the Supreme Court, but in respect of matters of public importance. In exercising this power, the Supreme Court regulates itself, and there is no appeal against a decision passed whilst exercising jurisdiction under Article 184.3 of the Constitution. 184.3 is the power of this extraordinary power of which is referred to as suo moto. Therefore, extra care must be taken to make sure that this jurisdiction is carefully exercised, and jurisdiction exercised only when the stipulated two preconditions are met: public importance and enforcement of any of the fundamental rights. The Supreme Court, as stipulated in Article 184.3 of the Constitution, must ensure the enforcement of fundamental rights while remaining vigilant that it does not stray into governance and policy issues. The Supreme Court must also not undermine laws made by the elected representatives of the people while exercising its extraordinary jurisdiction under Article 184(3) of the Constitution. Laws can otherwise be challenged. Anyone can throw a challenge to any law, saying that it is contrary to the Constitution, but this would be its normal jurisdiction, not the extraordinary jurisdiction where the court itself decides that some law has been, unless it's so offensive to, I can't imagine an example. The Constitution, our Constitution, the present Constitution of Pakistan, became operative on 14th August 1973. But within 4 years, it was subverted and suspended on 5th of July 1977. The 8th Amendment to the Constitution was enacted on 11th November 1985 to provide safe passage to the general who had violated his oath of office and the constitutional order, and also to provide constitutional cover to the laws promulgated during his tenure. So I mentioned earlier that ordinances naturally die after a period of 120 days, which is a presidential ordinance, but you will find many ordinances still on the statute books, and that is the reason. For instance, the income tax ordinance, otherwise an inoffensive kind of document, but since it was an ordinance promulgated when the constitutional scheme had been disrupted, it had to be saved, and this was done by Parliament amending the Constitution. In this case, it was done by inserting Article 270A into the Constitution. These A's are very interesting because the original text did not have A in it. But we were not done with just the one A. The Constitution was again subverted and suspended on 12th October 1999. The 18th Amendment to the Constitution was enacted on 8th April 2010 to similarly provide safe passage to another general who had also violated his oath and the constitutional order, and also to provide constitutional cover to the laws promulgated during his tenure. This was done by inserting Article 270AA into the Constitution. Through the 8th and the 18th Constitutional Amendments, a number of other amendments were also made to the Constitution. These constitutional amendments also stipulated that the action of these dictators shall, quote, not be called in question in any court on any ground whatsoever. Why is the Constitution important? Frequent tampering with Constitution and laws undermine them. To ensure their durability, there must be longevity. That is, they must subsist for a considerable period of time to retain the original ethos. Misguided political experiments destroy the old order and undermine the credibility of the new. Subverting and suspending the Constitution and then validating such acts does a great injustice to the people of Pakistan and the social contract binding them and the country together. What was conceived in 1940, envisaged in 1949, and detailed in 1973 must no longer be disrupted. And I would now just want to thank Dr. Faez Hassan, Dr. Faez Hoodboy, I'm so sorry, for inviting me. It was out the blue. I received, he contacted me, and I was sort of thrilled, if I can use the word, that I was considered worthy to give a lecture, distinguished Iqbal Ahmed. I would also like to thank the organizers, Abhi Fizar Tawfiq and Masood Azhar Sahab. And I would just like to conclude by thanking all of you for attending. It's a somewhat dry subject. Thank you for providing me this opportunity to present the salient features of the Constitution. And now let us work together to make this glorious state into one of the greatest in the world. These are Faez's words. Thank you, ladies and gentlemen.